without any further delay, I will allow our guest to give you a brief overview of her experience and credentials from her, from her own mouth. She's more than capable of doing that. Before we bring on our special guest, I'm going to introduce to you our host. Make sure you've got your Zoom etiquette in play. But I would ask you, before you do that, just to unmute yourselves. Let's welcome each other, greet our host, so that we can get the energy right and, learn and grow together this evening. So welcome, Abdul Hakim. Welcome.
And warm welcome to you too, and to all of those who have joined us this wonderful, sunny Thursday evening. It's a rarity, so we definitely are going to celebrate the sun shining, not just shining, but actually giving forth or sending forth rays of heat. So we're going to enjoy the heat from the physical sun, but we want to also enjoy some heat from our special guest, who's going to heat up our future and give us something to look forward to. This is a very, 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 as already discussed prior to my coming, very important subject matter. And we're going to share with you how important it is, because the spiritual injection is such a powerful platform that you wouldn't imagine that some of the broadsheet newspapers take their lead from some of the things we're doing. So it's not ironic, nor is it coincidental that in the Telegraph and the Times today, that there is a discussion afoot by over 50 MPs who have broken away from the Conservative Party, who actually have claimed that inheritance tax is morally wrong, and should be killed off. So we'll discuss that a bit further, but it's no accident that is in the broadsheet newspapers today, whilst we were planning this for the last 4 weeks. Why is all of a sudden this is front and center amongst, conservative MPs who have enjoyed, the benefits of this, but now they're seeing the immoral nature of such, law. So to without any furthering, I will introduce or represent to you our special guest, who will have a deep dive today, and just to tie up everything we've discussed over the last 3 weeks as we're concluding today and preparing for our major masterclass. So without any further delay, please take your devices off mute to receive once again our special guest, our sister Norma Wright. Please receive her with appreciation. Thank you.
Welcome back.
Well, welcome, Sister Norma.
Thank you. Thank you very much.
Or is yours?
Appreciate that. Thank you.
Welcome back.
Hi. Hi, Jeffrey. Okay, so thank you for bearing with me. And on this beautiful sunny day, it seems a fitting day to actually conclude our triple series on estate planning. I think I've been over wills and lasting powers of attorney with you over the past 2 weeks. And now we want to concentrate on trusts. In respect of trusts, I've sent everybody that's attending this forum this evening a gift, and that is trusts in brief, together with a draft trust deed. Please note that the draft trust deed is not to be copied. I've copyrighted it. And in terms of that, it's got clauses that may or not be necessary for your estate. And in turn, it also requires additional clauses to fit everybody on each individual's subjective estate wishes. So, that's just a guide. So that is to see and to show you how much work goes into a trust. So first of all, let me go back to the will, because the will is the basis of the trust creation. And I'm going to share with you now, hopefully it works, 2 documents. One is the last will and testament, and I'm going to take you through that clause by clause. And secondly, I'm going to take you through the letter of wishes, which reinforces the trusts that have been created in the wills. Now, the type of trusts that I'm going to concentrate on today are: one, nil rate band trusts, i.e. the first £325,000 that the government allow you to keep in your estate without being taxed for inheritance tax. That's i.e. anything over £325,000 is taxed by this present government or previous governments at 40%. So think about it. Secondly, the resident nil rate band trust I'm going to discuss. That is when you pass your estate over to your direct bloodline beneficiaries, which include illegitimate children, also adopted children, but it does not include stepchildren unless they have been specifically named in the will and in the creation of the trust. The other trust I'm going to talk to you about is discretionary trusts. So those are three main trusts that I'm going to outline in the will. But in the example, I have put so many other trusts for you to have a look at your leisure. And yeah, speak to a professional, even me, if you want to, if you have any further queries. Okay, so without any further ado, I'm not sure how many have you seen a last will and testament, but you're going to see one now, okay? Don't be frightened, I'm not tempting fate. This is all about putting your estate in order. So I'm going to attempt to share this now with you, and I'm going to go through relatively quickly, because we've spoken about this over the past 2 weeks, the clauses in a will. Can everybody see that?
Yes, we can.
Okay, excellent. This is the last will and testament. That means the last instruction that I'm giving to people that I want my estate to be distributed to. Okay, the will is made by me, NWW, known as, you put pet names in there because not everybody is usually known by their name that's on the birth certificate. So to avoid any doubt, we also put pet names in a will, aliases, etc. We also put the birthday as well, because when we're trying to prove a will, the date of your birth and the date of death is crucial when we're going to apply for the grant of probate at the probate district registry. This is the clause that is most important in any will. And it says, I revoke previous wills. So the document that you're attesting to now revokes any previous wishes. Even if you told your girlfriend that you're going to give her half of the estate, it doesn't matter if you've told her. What matters, it's what's written down. So everything you've said before the date of this will is void, declared null and void by this clause. If you marry, your will or your estate changes. Your wife, husband, or civil partner is entitled to 50% of your estate. This is not California law, but this is why we put this clause in a will. If you expect to marry, the details of your will changes, but if you don't want your details of your previous will to change before the date of your marriage, this clause is important. Contemplation of marriage or civil partnership. And it says, I expect to marry or form a civil partnership with my partner, whoever, of whoever. And usually if you put the expected wedding date, that is also included there. But it has this proviso. I want this will to stay in force after our marriage or after the civil partnership is formed. So therefore, with that clause in a will, marriage does not change your wishes. Without that clause in a will, your partner is entitled to a proportion, a fair proportion of your estate. Okay? Freedom to revoke. This will is usually put in a mutual will, i.e., when a husband is doing a will that gives everything to his wife and vice versa. Usually mutual wills are irrevocable. But it says here, although this will is similar to that of my partner, wife, etc., we have agreed that either of us can change or revoke our wills at any time. You can change it, or you can decide not to revoke your wills at any time. I've done a will recently for a couple that were extremely tight, and I was happy to put that clause in that says neither of us can change our wills during our lifetime. So that will is going to stand the test of time. It doesn't have to be changed every 5 years, which is the recommendation. So the freedom to revoke clause is important. Okay. Secondly, appointment of executors and trustees. Executors are the people that you have decided to carry out your wishes after your demise. Executors are trustees of your estate. That doesn't mean there's a trust deed. They just keep the estate intact so that it can be distributed in accordance with your wishes. As I said before, normally people usually name members of their family to be executors, but the members of the family sometimes are not legally trained, don't know how to fill in the tax forms, etc., etc. So I would always suggest that you always use a professional to assist with the executorship process. Okay, is that okay? Can I rush on? Everybody's just okay. So this clause, number 4, is the appointment of executors and trustees. I'm going to rush through because I know that you're interested in the trusts. Organ donation. In the UK at the moment, everybody is expected to donate a piece of their organs unless they opt out. So my recommendation is to put the organ donation clause in the will, whether or not you want your organs donated or you do not. That is an important issue. Funeral arrangements. Now, some people do not know exactly when they're trying to arrange a funeral what the deceased's favorite song was, or what they want to be buried in, etc., what type of service they want. This is where you put your funeral arrangements. That's the next thing. So buried, cremated, you know, in a wicker basket with flowers, no flowers, dressed in the flag of your country, etc. This is the instructions for your executors in respect of your funeral wishes. And I think that is extremely important. Now we go down to the gifts, pecuniary gifts. These are legacies. So here, gifts of money, that's the first thing. Gifts of money can be shared equally between all your children. But if you have 2 children and one dies before you, and you still have this equal clause in your will, it lapses. So therefore, the equal clause will has to be changed. In terms of effecting your will, that clause is extremely important, because if you have more than 2 children and you say equally, and for some reason there is only 1 child when you die and the will is to be proved, the sum of money cannot be shared equally. So the effect of that clause is also needs to be understood by the executors who are executing the will. Specific gifts. You can leave specific gifts, i.e. my favorite pearl necklace to be worn on the first wedding of my first favorite granddaughter, etc. So this is where specific gifts are actually laid down. Specific gifts have a fallback provision, i.e. if the person that you want to give the gift to is deceased at the time or previous to you, and they have children living, that gift can pass to the children. Doesn't have to, you don't have to give this to your grandchildren, but this is, can you see where my cursor is? If you have a look at the 4th line, it says, but if any such child is unable to benefit, their gift shall pass to their own children at the age of 18, and the costs of packing, transporting, and insuring this gift is to be paid from my estate by the executors. That is a fallback clause, i.e. the gift is not going to the person I intended to, but it falls and passes down bloodline. Okay? Gifts of property. Now this is interesting. This is where we look at the creation of trusts. People say they own property, but we always do a check, because not always do you own your property in the manner that you think you own it. Normally, property is owned between a person and the building society. So in terms of that, we have to look at the land registry, check the land registry provisions, get the title number, put that in the will, etc., etc. So here, upon my death, I give my interest in whatever, for any property that is my sole or main residence as at the date of my death, His Majesty's land registry number XXX, and all contained possessions not otherwise gifted by this will, free of inheritance tax, free of charge, mortgage, etc. So that is a direction almost to the executors to say that if my property is mortgaged, the mortgage needs to be paid up from any money so that that gift can take effect. If the mortgage company repossess the gift, the property, that gift lapses. It cannot be given. So that's where that is. If you have a property and you have a partner and you want your partner to live in the property until they die, this is where the property life interest trust is created. It's dictated and stated in the will. I want you to remember this clause 10 because I'm going to refer to it again later. Okay, so here we say that we want the partner to live in the property free of rent during the trust period. Okay, they're entitled to live in the property, and the trustees will not sell the property without the life interest tenant's permission in writing. So the trustees cannot sell the property while the intended person lives there unless they get permission in writing. So that means the person that lives in the property at or upon your wishes has what is known as a life interest. That's where that clause is stated. Any income from the property should be paid to the life tenant for the duration of the trust period. I said before, trust periods are usually 125 years, but that is not written in stone. The trust can be until the death of the life tenant. It can be 6 months after the death of the testator. There's all sorts of permutations to this. And this is where the drafting of the trust comes in and is crucial. Okay, so you actually appoint trustees, you appoint a beneficiary, i.e. the person who has the life interest. I'm going to scoot along now because I don't want to go too much deeper into this at this particular time. Don't forget that if any of you have a business, your business is also part of the estate, i.e. the shares that you hold in the business is part of your estate, and therefore you should decree who you want to have your shares upon your demise. So this is what clause 11 is doing. Now, if we go back to clause 12, business property relief carries 100% tax exemption, but that is also sort of written in tax laws, and I'm not going to go into the minutiae of the business property relief tax exemption now, but the business property does not usually come into the equation of inheritance tax where you have to pay 40%. There's very, very particular rules in respect of business property relief trusts. Clause 13. If you're giving a gift to charity, this is where it is stated. If the charity that you're giving the gift to is no longer in existence, you have a clause called CIPRE. So that means if I'm giving my money to a dog's home and the dog's home no longer exists, I can also elect, or the executors can elect, to give the money to a similar charity carrying out the same purpose as the trust to which you wanted to dedicate your money to. So here we go through definitions. Definitions of the estate is paragraph 14. Administration of the estate is the instruction to the executors to convert any remaining assets so that the estate makes a profit. And then we go down to the distribution of the estate, i.e. the residuary estate. After all the specific gifts have been given, the property gifts have been given, there may be some things left over, and that is called your residuary estate. And this is where you dictate who and how your residuary estate is divided or left to. Here, it says, my trustee shall hold whatever remains, including any income earned after my death, i.e. my residuary estate, to pass to my partner, subject to him surviving me by 30 days. Okay? If your partner doesn't survive you by 30 days, then the residuary estate is passed down to the next of kin. 30 days is not set in stone either. You don't have to have 30 days. You can have 28, you can have 60, you can have 90. So therefore, these are all examples. The Cypress clause is there, and the step provisions. The step provisions are the guidelines. The Society of Vision are the guidelines for how the executors should execute a will, i.e. distribute the will according to the testator's wishes. And the final clause states that this is the last clause of my will and is only followed by the attestation statement. The attestation statement is on the next page, signed by, dated signature, and signed in the presence of 2 witnesses that are compost mentors over the age of 18. Okay. Now, if we go back to clause 10, this is what I want to show you, where the trust or the wishes for a trust is created. Property Life Interest Trust, clause 10, just here. Clause 10 and Property Life Interest Trusts are also reinforced, not just in the will, but in the letter or the memorandum of wishes, which is what I'm showing you now. Can everybody see that?
Yes.
Yeah. So this letter of wishes or memorandum of wishes is signed on exactly the same date as the will. It has to follow the will. And here, because the person in the will has passed their estate over to their bloodline beneficiaries, they are entitled, sorry, I've got a $sign there. They are entitled, or the executors are entitled to claim an additional £175,000 in addition to the nil rate band of £325,000. If there's a husband and wife, the benefit for the £325,000 passes from husband to wife, so that's £600, £700,000 plus the extra £175,000, which adds up to £825,000 before the estate can start paying tax. If this residence nil rate band is not in the will, not in the letter of wishes, then your estate loses out £175,000 and you have to pay tax on the £325,000 at the rate of 40%. So this is important. Now we had a trust, there's a property trust. Let me go down to the property trust. We've got a vulnerable persons trust here, i.e. if you do not want to give all your beneficiaries to actually inherit the money immediately or soon after your demise, you can elect to have their share of your estate placed in a vulnerable persons trust. This is different to a disabled person's trust, which I've explained in the notes that I sent to you earlier. But this is where the trusts or the wishes for the creation of the trust is stated in the will and in the letter of wishes. So I'm just going to read the first 2 paragraphs just for clarification of this. In my will, I have given an interest in a property to you on a vulnerable person's trust. I appreciate that I cannot bind you legally in any way, but I would like you to consider the following when managing this trust. And this is the instruction to the executors. It's not the instruction to the beneficiary, it's the instruction to the executors. You're giving the reasons you create the trust, because that is also important, because if there is a dispute amongst any of the beneficiaries, your reasons or the testator's reasons are taken into account by the court, and this is important to have your reasons stated clearly. Now, the reasons in this draft is I have decided to create this trust because so-and-so is and likely always will be unable to deal with their own financial affairs. And I would like to make sure that they are provided for the rest of their life. To reinforce that previous statement, there's another paragraph that says, it is my wish that you consider the needs of so-and-so to be the highest importance and that you benefit for the rest of their life by giving them any financial support that they require. It is imperative, however, that you apply your powers in such a way that it would not affect any benefits which so-and-so receives and may be reliant upon. By creating a vulnerable person's trust, you are opening the vulnerable person to a decrease in any benefits they receive from the state in respect of their disability. So the creation of this trust has to be very, very carefully thought out. So the next trust I'm going to discuss very briefly, because all the trusts are subjective, but I've just taken a snippet here for you, is a discretionary trust. So what you are suggesting to the executors is that your estate be placed in a trust for approximately 125 years to benefit not only your children, but your grandchildren and your great-grandchildren. So that means the property that you have worked hard for is ring-fenced. It's ring-fenced from being sold, but it can be rented, and the rent is the income for the discretionary trust. And that income can be distributed to the beneficiaries, i.e. your children, your great-grandchildren when they come of age, and your great-grandchildren. So it goes all the way down the line. So, yeah, Tara? Yeah.
So I'm letting you finish. I have some questions, but
Okay, no problem. No problem. Just let me finish, please. The other type of trust which I've placed in my explanations is a flexible life interest trust, i.e. a FLIT. So therefore, you have placed your property in trust for the benefit of your partner, but they don't have to live there. They can benefit from the income from your property if you want them to, by way of a FLIT, a flexible life interest trust. And therefore, funeral wishes, I would also repeat in a letter of wishes, or deliberate exclusions. And I think I went through deliberate exclusions before. If you know that you don't want anybody to benefit from your estate, i.e. especially your exes or partners or children that you don't get on with, it must be stated very, very clearly in the will and in the letter of wishes. So here, this is just a sentence that is a suggestion. I have intentionally excluded so-and-so from the provisions of my will And I would like to detail my reasons for doing so. So you detail the reasons because if the will is contested, your reasons are looked at by the judge at the probate registry and considered. Your wishes and the letter of wishes is your statement when you cannot be here to make the statement as to how you want your property to be distributed. So the two things go together. The last will and testament, which is the way you want your estate to be distributed. That is the first point in the trust creation. And that is coupled with the letter of wishes or the memorandum of wishes. Now, in terms of that, there are trusts that you can set up during your lifetime before your demise. That's the living trust and the asset trust, but I'm not going to go into these just at this particular moment because I'm concentrating on the trusts that are created by the will. Okay, I'll take a breather at this point before I go on to the other documents that I have for you. So are there any questions at this point?
I did have one. I want to know why at the beginning of the trust, why do you say I cannot bind you legally if they're doing what you asked them to do?
Sorry,
The first statement, the first paragraph in each of the trusts, there's a sentence that said, I know that I cannot bind you legally to.
That was in the letter of wishes.
If you go down.
In the discretionary, that's in the discretionary trust.
Yeah, why do you have to say that?
Yeah, because a discretionary trust is by its nature discretionary. So therefore, if you say, I want my property to be placed in trust, and on your demise, the property no longer exists, i.e. it's been repossessed by the bank because you couldn't pay off the mortgage or anything. The trust cannot be created. So therefore, I cannot bind you. The circumstances under which the trust is created is important. This is an instruction. It's not an edict. So therefore, a discretionary trust by its nature is discretionary. The executors are the ones that have to decide whether or not there are sufficient funds or if there's sufficient property to be able to be placed in a trust. Does that make sense, Tara?
Yes, thank you.
It's okay.
And I got one more question. I see Brother Abdul Hakim is looking, but the other question, is it possible to extend that 125 years? And if so, how?
Not at the moment, not at the moment.
It seems like there should be a way you could do something.
You're not the queen. You're not sovereign. Yeah.
I beg your pardon.
Right. Don't beg your pardon.
I beg your pardon.
Royal trusts and sovereign trusts, the Rothschild trusts, go on generations because they were created generations ago. That's how the Rothschild family, the Vanderbilt family, the Queen, the sovereign trust managed to pass their assets from generation to generation without taxes. The government put a stop to that. I think they put a stop to that and just let us, everybody that's left, have a trust only for 125 years. So therefore, when the trust is dissolved at the end of 125 years, the trustees at that particular time and the beneficiaries can elect to create a new trust for another 125 years. But that clause must be stated in the trust deed.
Okay, but what if after 50 years, you decide to redo it?
What do you mean? No.
If you can't do that, you can't just say, let me redo it. I'm trying to like get around this.
Listen, you can't decide because you may not be here. You're the settler. Let me take you straight away now because your trusts are here. This is the example.
Apologies, everybody in the room. This is very fascinating to me.
Okay. Take you to the example trustees. Can everybody see that here?
Yes.
I'm trying to make that as big as possible. Okay. So here, when I go down to the trust, okay, this is a draft trust deed, basically, and it will go down. I'm going to have a look for the term of the trust here. So you've got the trust name, i.e. the Terra Family Trust. It tells you exactly how your trust should be managed. And it will also give you the length of time. I'm going to go through it very quickly because I've sent this to all of you so you can read it at your leisure. So it will also, it should state the time that the trust, the term, I'm looking for the term. It's usually 125 years. There's a trust term here to hold for the benefit, trust, fund, beneficiary, excluded person. Sorry, lost my thread. Just let me go and find term. Maybe it's not there. No, it hasn't come. Usually the trust term here in the definitions of the trust deed, the term is placed here. So you've got the trust, you've got the property which is being set out in trust, you've got details in the definitions as to how the trust fund should be expended. You've got details of the beneficiaries. You've got detailed of this excluded person here. And usually in the definitions, there is also a trust term. And it looks as if there's not one here. So maybe it's not the best example, but here, trust term to apply, capital, excluded person, distributed bonus. Sorry, trustees, appointment of additional trustees. I think the term here, it's got trustees remuneration, has not been mentioned, but take it as read, Tara. 125 years, yes, from the date that it's signed, etc., from the date that it's created. And the HMRC, now that all trusts are being registered, will be looking at the trust and monitoring for trust tax and all sorts of bits and pieces. So the way that the trust is wound up is also explained in the trust deed. This is not a comprehensive example, but it's one that you can have a look at your leisure.
Okay.
Yeah. If I go to this trust in brief note that I've sent you here, and it says the definition of a trust is, I hold something on behalf and for the benefit of another. That's all a trust is. Okay. I have a favorite scarf and I'm keeping it for my granddaughter when she turns 18. I'm holding the scarf on trust. The beneficiary is my granddaughter. Property is in the same way. The trustees are holding and looking after your property on trust for the benefit of your beneficiaries, i.e. your children, your grandchildren, and your great-grandchildren. So here, the different types of trusts are inexhaustible. But for the time being, the trusts that we're going to concentrate on are 1, vulnerable persons trust, discretionary trusts, but not nil rate band trusts, and resident nil rate band trusts. Those are the most common type of trusts that need to be explained and informed to everybody in the United Kingdom that has property or has something that they want to share or leave a legacy for their beneficiaries. That is their inheritance. It's not just property, but the property must be properly managed. It must be kept intact. It must also make a profit, i.e. they don't have to live there rent-free. They must pay a reasonable rent because the rent goes towards the upkeep of the property. Are you with me?
Yes.
Yeah, so that's where those are. So please, at your leisure, have a look at my explanation for a nil rate band trust. Have a look at my explanation for a residence nil rate band trust. That's where you're passing your estate to your direct linear bloodline descendants. On that, the HMRC allow you another £175,000 before you have to start paying inheritance tax. That is important. Discretionary trusts, i.e. we just discussed, it's discretionary. If there is something to put in trust, then the executors must or should do it. But you cannot give them an edict. It is your wish. And it's for the executors to know or be advised as to how to carry out your wish that is related in your will. Vulnerable persons trust, i.e. for somebody that you don't want to inherit as soon as you die. Possibly they have an illness that they're dealing with, schizophrenia, for instance, and you don't think that they can manage a lot of money at that particular time. Put their share of the estate into a vulnerable person's trust and give instructions that says, as and when they get better, or at the age of 40, or some other trigger point, they can have their inheritance. Okay, that's a vulnerable person's trust, quite different to a disabled person's trust. So please read these at your leisure. Life interest trust, we've gone through, i.e. somebody can live in the property until they die, but the property is passed then over to your children, i.e. suppose you're in a blended family or you're in a second marriage and you've worked hard and you want the property to go directly to your children, but your partner or your husband or wife is living there and you want your wife to live there until they die, and then the property is passed over to your children. So that's a life interest trust. You can have a clause in a life interest trust that says, if my partner remarries, then this trust is to be dissolved. Yes, they're not allowed to live in the property. I did one for a couple that said, if my husband wears yellow socks, if I'm not here, I don't know what this lady had against the color yellow. He cannot continue to live in the property. If I die, the property has to be passed to my children. So, she's almost dictating what he can do from the grave. Okay. Then we're going over to the flexible life interest trusts, which you can give your partner an income. And then further down, constructive trust. This is something that I have been discussing today with an accountant. I've got some trusts to do for people who have been living in a de facto trust position for the best part of 10 to 15 years. In that instance, I have to have a look at the circumstances, and I can almost de facto create the trust, which is almost backdated in terms of circumstances, but it's not backdated in terms of signatures. And I have to prove to the Inland Revenue that the trust has been in existence for the best part of 10 to 15 years, and that is called a constructive trust. The other type of trust that we're looking at, or can be created before your demise, is an asset or living trust. It's an asset or living trust because the trust is created during your lifetime and not on your demise. These are the two types of trusts that can be created through your lifetime: a constructive trust, a life interest trust, and an asset and a living trust. I've named some types of trusts for you here on page 6. Bare trust, interest in possession trust, mixed trust, non-residence trust, charitable trust, revocable trust, irrevocable trust, and a revocable -trust. That's not a spelling mistake. Items number 6, 7, and 8 are all different types of trusts using the word revocable. Spendthrift trust, you can guess what that is, i.e., I want my beneficiary to have, only £100 a month from my estate until. So you can almost control in a trust what happens and how your estate is distributed. There are some terms for you. Settler is the person that creates the trust. Trustees basically is the person that manages the trust. And the beneficiaries, okay, 2 classes, primary and contingent, are the people that benefit from the interest of the trust, the funds. They don't benefit from the capital. It's not wise. If you keep giving the capital of your trust away, the trust dwindles. So therefore, the trustees have a very important role in ensuring that your trust is profitable. So there we are. So things that you can put in a trust: cash, property, shares, land, etc., etc. Cash, yes, I think at the beginning of this series, somebody said you can put your salary in a trust. Yes, you can, but your salary is your living expense. So therefore, why would you put your salary into a trust? Put your savings into a trust over the value of £5,000. That's money that you do not have to spend on an everyday basis. Does that make sense?
Yes, that makes sense.
Property, i.e. antiques. Property doesn't just have to be bricks and mortar. It can be your silver collection. It can be your gold collection. It can be your Hamilton motor car. It can be your favorite Omega watch, etc. Those are things that are classed as property. Chattels, assets, that is property when we're talking about trusts. Shares, i.e. shares that you have in a company. People went out and bought a lot of British Telecom shares. Therefore, on your demise, who do you want those shares to go to? This is all trust property.
Can I just interject, Sister Norma? First, thank you for such a brilliant, in-depth presentation. We really, really, really appreciate it very much. One of the things I wanted to add, just before I allow Tara to come back in, is what about your pension? Is your pension also something you can put in trust?
Yes.
And, okay.
Yeah,
and
because your pension normally, on the death, your pension is given to the next of kin, the wife or the husband. Okay, doesn't have to be so. Pension companies will tell you and get you to sign the pension in trust for the wife or the husband. You can skip a generation and put your pension in trust for your child, but there is certain criteria that have to be met. So every pension company is different. Yes, but
is it
taxable? It is possible.
Is it taxable? Is it also taxable?
Pensions are not taxable at the same rate as the usual inheritance tax. They have a different tax regime, okay? The tax laws in this country are harsh, okay? And in terms of what the 50 conservative politicians are doing, they're trying to preserve their seat at the next election because they know IHT is very unpopular. And if the government is making, let's say, 33 billion from inheritance tax, do you think they're going to let that go? So I'm watching this with a very fine tooth comb. Life assurances, as well as pensions, can be put into trusts. And quite a lot of IFAs will tell you to sign your life insurance into a trust for the benefit of another party. if it's signed into trust upon your demise, it escapes your estate. So therefore, it's not calculated amongst your estate value. And that is the benefit of a trust. It cuts down your estate value. So therefore, the 40% tax that you will be paying over the nil rate band or over the residence nil rate band is diminished. And I'm not giving you tax advice, okay? This is a disclaimer.
Quite to the contrary.
I'm not telling you how to circumvent paying tax.
Perish the thought.
Okay.
You're just having a conversation.
Okay.
On these crucial areas.
We are just moving, yes?
Yeah, that's all we're doing.
That's
for the record. So just to add to that same point in regards to then a pension. So then is it wise for someone to stack their pension up and make it as large and as, you know, profitable as, well, not profitable as such, but as large as possible?
I am not an accountant. I'm not a tax advisor, but yes.
Very good. So tell me, because there are many who say, okay, you know, I don't have X amount of money, you know, and I don't have property beyond this amount, et cetera, et cetera, et cetera. So, you know, this is not really something that I'm inclined towards learning. What would you say to those who have that kind of attitude?
I would say, even though you think you have nothing to give, you have something. And your legacy is anything that you think is of value. Even if you have your Bible that has been underscored, etc., that is a piece of your legacy. It's a specific gift that you can leave to somebody. If you do not put your wishes in a will, nobody's going to know who you want to leave your favorite Bible or your favorite book to, or the first edition of Wuthering Heights. What I find really sad is going around charity shops. Where I live, we have quite a few. And the things that people have left when on their demise, the executors do not know what to do with. They put them in charity shops. Clothes, for instance, shoes, you know. You could decree that all my clothes could go to the British Heart Foundation. And that's what your executors has to do. But invariably, people do not put specific wishes or have a very, very detailed will. So therefore, on their demise, the executors and the family do not know what to do with their assets. Pots and pans, favorite knives, etc. You know, think about it. That's all I ask.
I'm of the mind, Norma, that what you have shared with us over the last 3 weeks really should inspire every last one of us to really appreciate how important it is to be educated.
Informed?
Yeah, like to be inspired, to be educated. Because if one does not desire or have any interest in being not just basically educated, but educated around your life and what the responsibilities are in regards to just being alive and having some kind of advantage, how much that has to be structured, right? Because sometimes we just, this whole area really has passed by a whole generation of us.
It has.
Literally. And we have a lot of catching up to do based upon what you've just shared.
A lot of catching up. And this is where I love history. In Buckinghamshire, where I live, there's a host of wealthy families. And it's not because their bank accounts are large. It's not because their bank accounts have been passed from generation to generation. It's not. It's because they have tied up their wealth and told generations what to do with their wealth in a trust. You can say in a trust, I want each of my children or my grandchildren or the first of the next generation to go to university. So therefore, the trust has been maintained. So the trust funds are invested. So therefore, the trust increases to be able to send your descendant to university free of charge. Yeah.
It sounds like, Norma, if we had this information at a younger age, then we would be much more mindful of who we would even consider for marriage and consider for a relationship. But because we don't have this type of very important knowledge, we seem to throw our futures away and roll the dice, you know, where if we had something to gain and we knew the decisions we were making would be against what we have to gain, then I think we'd be much more careful, would we not?
I totally agree. We would be much more careful, because in my view and in my experience, each generation is more intelligent than the generation before it. So we are standing on the shoulders of our ancestors. Our ancestors passed things down by word of mouth. These days, in this technological age where, you know, 98% of the country can read and write, we need documents to pass things down from generation to generation to generation. And this is where wills and trusts and memorandums and all sorts of written documents come in. It's important. And as I said before, it's my quest to actually inform people, not necessarily educate, but inform people as to what they can do to preserve their legacy.
Fantastic. Tara? I've left a gap for you.
Yeah, I'm just sitting here thinking, because it's like having this information at a young age would allow you to understand really how wealthy people stay wealthy.
Yes.
Understand that they keep it's like that's a huge advantage. You know what I'm saying? And understand, like, it's just like, it's not a game, but it's something you can just really just, if you knew about it, you could just do it and you could be on more of a level playing field. You know what I'm saying?
Yeah, Tara, I think we have a responsibility to preserve our legacy for the next generation. I think we really do. I think it's extremely important.
And
it's our responsibility.
Difficult.
Yeah, it's
not difficult. It's just writing something and having it worded the correct way.
Yeah, we have been standing on the shoulders of our ancestors. Now it's our turn. Yes, so that the next generation can stand on our shoulders. And this is how you do it.
I do have a question. With the trusts, I know you said if you have a mortgage or something, it's best to make sure that all those things are paid. You know, you are making income. But is there any way that things that are in the trust that are secured could be taken away? I know I'm saying like taken by the government. You know, say for example, you have things in the trust and you've willed it to your family, you know, your children, grandchildren, but for some reason, is there any way anything that's in a trust can be taken away from the family?
Okay, when you say taken away, that's a phrase that has many different connotations.
Well,
taken away can be what? Taken away can be sequestered by the government. It can be loaned to the government, i.e. people have art. If you go to the National Art Gallery, quite a lot of the paintings in the National Art Gallery are loaned to the National Art Gallery because they are in trust, and most of them are owned by very wealthy families. The Rothschild collection, yes, for instance. So therefore, taken away has very many different connotations. If something is willed or it's placed in trust, they are two different disciplines of how you ring fence property, Tara.
Okay.
If you will something, a will is a future wish. Yes. If you think of it that way.
Yeah.
A will is a future tense. I will. I want to. Yes, it's future. This is my last will. This is what I want to happen to my estate. And testament. This is what I'm stating I want to happen. The duties of an executor are extremely important and extremely onerous, because if you do not carry out the wishes of a testator, the government will come down on you like a ton of bricks, because you have reneged on your fiduciary duty to the testator. So when people are putting people in the position of an executor, I do not think they know the burden that they are placing on the executor's shoulders. That's why I would always recommend that you also use the services of a professional when you do an executorship or take on the role of an executor. It's onerous. You can be fined, you can be imprisoned for not carrying out the wishes that are in a will within a reasonable period of time. The government gives you, or HMRC, not the government, gives you a period of 6 months from the date of death to actually report the estate accounts to the Inland Revenue, failing which you're liable to pay a fine, or you're liable to pay the inheritance tax 100% straight up front. Normally, when we put an inheritance tax valuation to the Inland Revenue, we can negotiate how that inheritance tax is paid by installments. Not always people have 40% of the estate value to give.
Right.
Sometimes the property has to be sold. If the property has to be sold and somebody has left in the will a property trust, the property trust lapses, or the executors have to find a way to get the money to keep the property so that the property trust is set up. Yeah?
Right.
Yes.
Am I making sense?
Yes,
Yeah,
you're making
absolutely.
sense.
I just want to chime in on that point and on that particular point. And I'm going back again to the importance of why we have to educate our children.
Yes.
Because we're going to need someone in the family who would serve as an administrator over the affairs or the affairs of whoever passed. And we know
That's right.
family members are going to pass.
Executor, Abdul.
Yeah.
Yes.
Yeah. So
Language.
we must have, plans to ensure that we have executors in our family who know what to do when, the uneventful evil accident of time, visits any last one of us. Very important. And I think sometimes we approach life so emotional, that we make excuses for ourselves, right? And make excuses. Oh, we were so busy working, so busy doing this. Well, we shouldn't be too busy working, amassing wealth and looking after our children if we're not preparing them for the future. Yes. Because if we're not preparing children to stand on our shoulders, then we're having children and preparing them to perpetuate a society that is stacked against us.
We are failing them.
Yeah, so I don't know how that becomes useful, just to make excuses of why we don't have qualified members of our family or our community to take us to the next step. We can't use working hard as an excuse, because working hard for who? When you work hard, it means you move something forward, I would have thought, for your benefit, as opposed to build a company for somebody else who won't even attend your funeral.
Progressive. We have to be progressive.
Yeah, so which brings us to, our conclusion. We really want to thank you for the time that you have given to us, Norma, because you've gone into extreme detail to ensure that we understand what you have shared with us. And we're not going to take any more of your time, because we've got a wonderful masterclass coming up with you, where we will have you to ourselves, those of us who want to take this forward and dot all of our I's and cross all of our T's, and actually leave out of this, not just with another spiritual injection, series and episodes, but actually as a result of the last 3 weeks, I have put my family's affairs in order. That's what we want the serious ones of you on the line to say. As a result of being on here for 1 week, 2 weeks, for the last 3 to 4 weeks, I have now, started the process of getting my family's affairs in order. Is there anybody like that on this Zoom today? Can I see a show
Can I
of
just
hands?
add one thing?
Please.
If that statement is honestly confessed, my work will not have been in vain. Yes? It doesn't matter if you come to me to do it. It doesn't matter if you go somewhere else to do it. All I need to do is inform you, put your affairs in order, and that is my job done.
Well, spiritual injection, let's put a 1 in the chat to let our sister Norma know that her work was certainly not in vain. Let me see those 1s. Because your work was not in vain. And we can confirm and affirm that you have been a blessing to us, and we have taken your words and your guidance to heart and will implement them into our family affairs. I've even got brothers firing shots in the audience. Boom, boom. Is that right, Brother Paul? So with that said, spiritual injection, give Sister Norma Wright a massive, well-deserved, beautiful round of applause for the wonderful information she has shared with us.
Thank you so much. Thank you.
Thank you.
Thank you, everybody. It's been a pleasure.
Thank you so much. Thank you.
Fantastic. So sign up for the masterclass and ensure that you complete the cycle of education that we have been given by our beautiful sister, and attend the masterclass and make sure that you leave, or we will ensure that you leave the masterclass, as the executor for your family, because you should plan to become the executor of your family and move away from all of the emotion, because there's too much emotion around death in our families and in our community. We've got to be a lot more forward thinking and a lot, less emotional, and be practical and call on those members of our family when there is sickness and when there is the passing or there is death. Okay, we call our executors. Okay, we don't just start crying as if we just want to act as if we really love the person who is dying because we're trying to get our hands on something. Let's call the executors, okay, who will ensure that the right thing is done by this loved one who has contributed mightily to our bloodline. Okay, so with that said, next week, family, we're going to have a very special guest, because our sister Norma has been showing us, the importance of structuring our wealth. Well, we need to build wealth. And in order for us to build wealth, we've got to learn how to choose a good partner for ourselves, okay? How to choose a good partner for ourselves, because we just don't want to be lovey-dovey. We also want to amass some wealth so that we can enrich our bloodline. Can I get a witness? Any witnesses in the house?
Amen.
So therefore, we're going to have a brother come on next week, and he's going to ask, or he's going to answer the question, how to love a Black woman and how to love a Black man. We have Brother Nuri Muhammad, who's our special guest next week, to discuss the book that he has written, How to Love a Black Man and How to Love a Black Woman. And there's a clip we're going to play you from a statement that was made by Steve Harvey. Have you, on this particular brother and the book that he has written? Do we have it queued up, Sylvina? Sylvina?
Yes, we do. Yes, we do.
Roll it?
Yes, we do.
Let's roll. Please listen. He will be our special guest next week. Please listen.
Now I know they tired of hearing me saying, but what you want me to say? Shit, I ain't got nothing else for you. Shit, it wasn't just all me. Right. She gave me the mindset to be me. And that's crazy, man. It's like there's a dude named Nuri Muhammad. I wish I had my phone, man. You could hear what this dude said about relationships. It's the coldest thing. He said, other than your relationship with God, who you choose to spend the rest of your life with is the single most important decision you will ever make. Because your other half will be your better half or make you half of what you could be. She will either inspire you to greatness or reduce you to mediocrity. And then he went on to talk about, he quoted Minister Louis Farrakhan, and then at the end of it, he said, so choose wisely. And that was the first time, man, that I'd ever chose wisely. And it was the best thing, because a woman like an elevator button, man, it can take you up or down.
We want to help you, brothers and sisters, to ensure that we all go up. And there's a very powerful song that goes, the only way is up. So we want to give you some guidance from Nuri Muhammad next week on how to go up, because we've got a lot of work to do, okay? So get your tickets early, because we have a limited amount of seats in the Zoom room. So if you want to be in the Zoom room, please get your tickets early. So for this week, though, all the applause, all the adulation goes to my sister, Norma Wright. Let's give her a massive, massive round of applause. And